I'm asking Your Honor to again revisit the bond conditions.
Counsel, I'm in the same position I was the last time, I think.
He just wants to be able to get out and help with the care of his child, Your Honor.
Started to punch her multiple times in the face, put her in a headlock, and strangled her to unconsciousness.
Hearing repeat. That means the defense is trying again to loosen conditions, but in court often means we didn't win last time. Let's see if the judge feels any different today.
Good afternoon, Your Honor. Ellen Michaels on behalf of James Worthington. My P number is 67943. Mr. Worthington is present in court.
All right. Your name, sir?
James Worthington.
All right. Very good. All right.
So today's the date time set for our second probable cause conference. We'd adjourned it in order to get all the Child Advocacy Center videos. I'm short 2 videos, though I've been notified that they have been sent to me. So I believe we're ready to set it for exam.
These Child Advocacy Center videos are crucial. They often contain interviews with minors in sensitive cases. Missing footage could delay justice or alter case strategy entirely.
Assuming that they, in fact, were uploaded today as stated by the prosecutor.
For clarification purposes, I have confirmation from the detective, the officer in charge, that they have just as of today been shared and made available on evidence.com. I've relayed that information to the proper individual in our office. I would expect that those will still be shared with counsel before the day is over. But just to be clear for the record.
All right. And if those are done, then discovery is complete.
Yes.
Yes.
Don't like to do it this way, but I get what you're saying, that it's there.
Understood, Your Honor. Thank you.
If there is a problem, I will bring it to the court's attention and file the appropriate stipulated motion in order.
Right. But that's what we try to give people time at PCC to get all that stuff straight and not set something and then have it adjourn out. So
Understood.
I want to make sure that we're going to be able to go forward. People had their witnesses available the 28th?
28th of
January.
what time?
9 a.m.
Oh, I'm not available at all that day. I have a 9 a.m. exam and a 12:30 sentencing.
February 4th
Checking.
or February 11th.
What time? February 4th, 9 a.m.?
No, you're all at 9 a.m.
February 11th. February 11th is good.
Preliminary examination in person, February 11th, 2025, 9 a.m. before. Am I ahead on that list? Okay. Before.
Notice how the attorney emphasizes reunited with his children. That's a strategic emotional appeal, but in alleged abuse cases, any child contact request raises huge red flags for the prosecution.
Okay. Before Judge Valvo.
I didn't hear the name. What name?
Valvo.
Thank you.
Bond will continue.
I'm asking Your Honor to again revisit the bond conditions. What I'm simply asking is that my client be reunited with his children. He does not need to go back to the residence that's across the street from where the complainant lives. The family can stay with a friend in a separate location, but since the incident that the 2 children of my client have been taken away, even though CPS has not filed the case has been closed. There's no issues. The children are staying with grandparents, and this has been going on since early December.
Your Honor, people continue to object to that. Again, as I indicated the last time you were here with the same request, I get that. I really do.
This is the moment that shifts the entire case. The alleged victim's friend accuses not just the defendant, but also his daughter and son. It's no longer a simple bond issue. It's about child safety and credibility.
I'm not comfortable agreeing to that because although I understand that defendant's daughter was interviewed at the CAC and did not disclose. That being said, our charged victim, her first trial best friend, in her CAC interview, where she made all of her disclosures, she indicated that his daughter also told her that she had been sexually assaulted, both by defendant and by their son, who's as well. Well, I am concerned. I'm not willing or able to agree to change those bond conditions. Understanding, obviously, ultimately it's up to the court, but I have concern for the safety of any minor child.
And I'm quite frankly, counsel, I'm in the same position I was the last time, I think, that, I don't think anything's changed, and I denied the request the last time, and I don't have any additional information that would lead me in that other direction. So I'm going to decline. I'm not going to change its bond conditions.
Can I just make a record on one matter?
Sure.
Thank you so much. My client's daughter, Lila, who the prosecutor was talking about, she was taken by the police to University of Michigan Hospital and physically examined. There's no indication of any.
The judge's right here lack of medical evidence doesn't prove innocence. Many child assault cases show no physical signs due to healing or the nature of the act. It's one of the most misunderstood parts of sexual assault law.
Sexual assault. She was also, as stated, interviewed in a forensic setting and did not make any disclosures. We believe this is all part of these are all false allegations, and the children, there's no evidence that his children have been assaulted in any way. This is part of the discovery that was tendered to me by the prosecutor, the medical records and her interview.
Judge, as I indicated last time, same record was made then, same arguments were made then.
I know.
Certainly the court has been doing this as long as I have been doing this. There aren't hardly ever medical findings when a small child has been sexually assaulted. It's all about timing. It's all about type of sexual assault. It's all about those areas of our bodies being fast healing. It's all about so many moving parts that a lack of medical information means zero things in terms of whether or not a child has been sexually assaulted.
One more thing, Judge, that the allegations are that the daughter allegedly said that my client penetrated her every single day. There would certainly be medical evidence of that. Thank you.
It would not necessarily be. Penetration can be a whole lot of things with a whole lot.
Yes. And again, I know you made your record, but I'm still at this point going to deny that. Judge Valvo, after the damn happens, may feel differently, and certainly you can bring that before her. But at this time, I'm going to deny the request. Bond will continue.
Thank you very much.
Thank you.
Thank you.
Court does call the case People versus Elijah Campbell.
And then on behalf of the people,
Stephanie Can on behalf of Mr. Campbell, who is appearing to my right. Mr. Campbell, could you please state your name for the record?
Elijah Campbell.
Another bond plea, but this time from a new defendant and a heartbreaking twist. A newborn in the NICU emotional stakes meet violent allegations. What would you do if you were the judge here? Drop your thoughts below.
Thank you.
Your Honor, today is the date and time set for PCC on this. My client is asking for a preliminary exam on this matter. He'd also like the opportunity to address bond with the court when appropriate.
Is all discovery complete?
To my knowledge, yes, Your Honor.
What date are we on? I'm sorry.
28th.
Preliminary examination will be set January 28th, 2025, 9 a.m. before Judge Barr. I'm gonna have to speak up. I can't hear. As to bond.
Thank you, Your Honor. My client is asking for the opportunity to be released on bond. He does have a child that is very sick, is in the NICU at, I believe it's Mott. Very premature, very sick baby, Your Honor. He is asking for the opportunity to be released. You can tether him to his home. He just wants to be able to get out and help with the care of his child, Your Honor.
Response.
Oppose any reduction in bond. This defendant has numerous disabilities, as well as CCW, And in this case, he accused the victim of seeing other people, got upset, and started to punch her multiple times in the face, put her in a headlock, and strangled her to unconsciousness. She said she was going to die. When she woke up, he got angry again. He tried to hit the wall so someone would hear and call the police. He then came up behind her, strangled her again, threw her to the floor, got on top of her, hit her again, and then grabbed the TV remote and hit her with it so hard that it broke the remote. He then picked her up because she was unable to get up herself, put her on the bed, told her to give him money for an Uber so he could leave, and then left. And the victim in this case had black eyes on both eyes, swelling on the left side of her face, and scratches and abrasions on her neck. So given the facts of this case, we would oppose any reduction in bond, Your Honor.
Anything additional?
Your Honor, just that all those cases were dismissed. And my client is innocent until proven guilty, Your Honor. He's just asking for the opportunity to get out and care for his sick child.
Motion for bond reductions denied. Bond will continue.